There are two main ways to know if you have won your Social Security disability hearing. The first way is if the vocational witness that's present testifies that there are no jobs available that a hypothetical individual can do. And the second way, of course, is if a judge issues a bench decision and tells you during the hearing that they are going to find favorably. With the first, which is that the vocational witness who's present testifies that there's no jobs available for you, that one you do want to be careful with. Oftentimes, judges will give several different hypothetical questions, some of which might result in jobs being available, and some of which might result in no jobs being available. The difficulty is if you have that type of situation where some hypotheticals, there's a job available, and in some there aren't, it's hard to tell without knowing the judge which of those hypotheticals the judge is going to use to base their decision on. So you've got to be careful just because a vocational witness testifies that there are no jobs available. If there is at least one hypothetical asked of the vocational witness by the judge that results in jobs being available, a denial is still possible. However, if a judge issues a bench decision and says in the decision that, or says in the hearing, that they are going to find you disabled as of a certain date, and sometimes they'll tell you kind of what their rationale is that to expect in the decision, that's a little bit more concrete. Either way, if you've got an attorney who is present with you in the hearing, he or she might be able to shed some guidance, especially if you've got a vocational witness testimony that had some jobs available and some testimony that said there were no jobs available, that you would want to have your attorney ask him or her some questions about it to see if they have any idea where the judge is leaning. Ultimately, though, you won't necessarily know the judge's decision until you actually get the decision in the mail.